The topic for today is to talk about the importance of legal advice before proceeding with an unlawful detainer action. So, landlords are the people who proceed with unlawful detainer actions, property owners. So this video is for landlords. In 2007, I became a real estate licensee, and since then, my experience has been primarily in the residential and commercial property management industry. In 2012, I earned a bachelor's degree from the University of Phoenix, and just recently in 2018, I earned a Juris Doctor's degree, and I passed the California bar. So I've only been a lawyer for about 8 months. My background, however, in property management required that I become very familiar with consumer protection laws, housing laws, real estate laws, and various laws that affect the landlord-tenant relationship. So the difference now that I am a lawyer is that as a property manager, my understanding of the law and the way that I used the law was to ensure that my clients and myself maintain compliance with the law. But now that I'm a lawyer, I engage these laws a little differently, where I'm able to advise individuals on what they need to know when there is non-compliance with the law, whether a tenant is in non-compliance or whether an owner is in non-compliance, particularly with owners. Tenants usually are in violation of contracts, where owners, there are specific laws that govern how owners should conduct themselves and conduct business with tenants. And I'm also able to determine whether there's non-compliance and what the various rights are with respect to interactions between landlords and tenants. So that's a general background and how I have come to a situation where, as a lawyer for only 8 months, people are already considering me a specialist in the landlord-tenant area. And it's important to note that while my experience as a lawyer has only been about 8 months, my training in school has put me in a position to be able to conduct research and analyze laws so that I can help my clients. But when it comes to landlord-tenant law, there's some pretty common areas of the law that are often implicated. So I guess I can give an example of how legal advice is very important prior to engaging in unlawful detainer proceedings. So in this scenario, there is an owner, and an owner is upset because his tenant has not paid him for rent for the current month. The tenant owes the landlord $3,000, just 1 month's rent. And the tenant is over 10 days late. And the landlord, however, wants to save money. The landlord doesn't want to spend a lot of money, so the landlord chooses a company that will help the landlord complete the paperwork to file an unlawful detainer and not give the landlord any legal advice. And that landlord understands that if the tenant answers the complaint, that the landlord at some point may have to talk to a lawyer or have a lawyer appear for the landlord in unlawful detainer court. Nevertheless, in this scenario, the landlord authorizes the eviction company to prepare and post a 3-day notice to pay or quit. And when the tenant did not pay the $3,000 within that 3 days, the landlord authorized this company to file an unlawful detainer action on behalf of the landlord. In this scenario, the tenant answered the unlawful detainer action. And on the answer, the landlord or the tenant raises the affirmative defense of breach of the warranty of habitability. And in fact, the tenant provided proof of the breach of the warranty of habitability. The tenant provided reports from mold inspectors. The tenant provided notices and correspondences that went to the landlord from code enforcement, and reports from code enforcement indicating that the property is not in compliance with health and safety codes. The tenant, most importantly, provided reports and from doctors indicating that the tenant's health is in jeopardy because of these conditions on the property. And the tenant also noted that the tenant has given up possession of the property because the conditions were so bad that the tenant had to move, right? So in unlawful detainer proceedings, the primary purpose is to determine who has the immediate right to possession. So because of this, these proceedings are usually quick and expedited. They're not like normal civil cases. And in these proceedings, the tenant can only respond to a complaint in so many ways. And but when the tenant comes in and tells the court that possession is no longer an issue because the tenant has moved out, eventually the court is going to dismiss the unlawful detainer complaint. Okay, doesn't sound like a big deal. The owner wanted possession of his property or payment, 3-day notice to pay or quit. However, the owner also asked for some money, $3,000. And what happens in an unlawful detainer case, fortunately for owners who really want to collect this $3,000, is that once the case is dismissed, if there are still some issues with respect to the lease, the action converts into a civil case. Now, it's a normal civil case. These are not expedited procedures. This is just like every other lawsuit that can take months, even years, to conclude. And now, procedures that were not available to the tenant in unlawful detainer court are now available to the tenant in a civil action. In unlawful detainer court, the tenant cannot make what is called a cross complaint against the landlord. The tenant cannot sue the landlord in unlawful detainer court. The tenant can only raise affirmative defenses, as is here, the defense of breach of the warranty of habitability. But once the case gets converted to an ordinary civil action, the tenant now has available the right to file a cross complaint against the owner and bring claims against the owner. Now, the tenant's defense of breach of warranty of habitability can now be put forth as a complaint against the owner for breach of the warranty of habitability. And now this owner, who wanted to save money to collect $3,000, played a few $100s, has to figure out how to defend against a tenant's complaint for breach of the warranty of habitability, asking for $500,000 in damages. Had this owner sought legal advice prior to filing the unlawful detainer complaint and understood all of the issues and questions that should be answered before a landlord proceeds with an unlawful detainer complaint, maybe the landlord could have resolved this issue in a much more favorable manner. But now the landlord, who paid a few $100s to this company, who was only trying to seek $3,000 in possession, finds himself having to pay lawyers more than $3,000 to defend against this $500,000 lawsuit. And that, my friends, is why before filing an unlawful detainer complaint, you should contact an attorney that is aware of the laws governing landlord-tenant relationships. An attorney who understands the rights of landlords and tenants and the various issues that should be considered prior to filing an unlawful detainer complaint. My name is Andre L. Clark, Esquire, and if you have any of these type of issues and you're a landlord and you want to know whether it's appropriate for you to move forward in an unlawful detainer complaint, don't hesitate to give us a call. We're open 6 days a week. We'll get someone to call you back as soon as possible. Thank you.